夠人又夠鐘。
We've already formed a quorum and it's time for us to start. Today we have a heavy downpour. I was worried that we might have to abort this meeting. Please invite the government officials to come in. Good morning. Attending this Bills Committee meeting are Mr. Arsin Yu, Principal Assistant Secretary for Financial Services and the Treasury, Ms. Phyllis McKenna, Deputy Principal Solicitor, Mr. Chung Wai Tim, Acting Senior Solicitor, Mr. Lau Ka Kam, Mrs. Karen Ho, Deputy Principal Solicitor, Ms. Nancy Yao, Acting Deputy Registry Manager, Ms. Amy Chan, Senior Government Counsel, Ms. Phyllis Poon, Senior Government Counsel, Ms. Mandy Ng, Acting Senior Government Counsel, and Ms. Cindy Chuck, Government Counsel. Thank you for attending. At the meeting on the 3rd of June, members already completed the clause-by-clause scrutiny on Companies Unfair Prejudice Petitions Proceedings Rules, Companies Revision of Financial Statements and Reports Amendment Regulation 2013, and Companies Disclosure of Information about Benefits of Directors Amendment Regulation 2013. At members' request, the administration has already submitted papers to us. Paper 1268, bracket 02, and another submitted before this meeting on Companies Unfair Prejudice Petitions Proceedings Rules. I'd first of all like to invite the administration to introduce those papers to us. Thank you, Mr. Chairman. At the last meeting, members raised certain queries about the Companies Unfair Prejudice Petitions Proceeding Rules. We've provided some information on that, including concerning the correlations between the various pieces of legislation. We've provided an explanation. If it is just an unfair prejudice petition, then the new rules will apply. If it is a simple liquidation situation, the liquidation rules will apply. If it is an unfair prejudice petition as well as a liquidation petition or winding up petition, then the rules will apply to both. It is clear that if there's any discrepancy, we'll follow the company's winding up rules, so there won't be any confusion for the parties concerned. Last time members asked another question. If it starts as an unfair prejudice petition and a winding up petition follows. In paragraph 4, we say that if it starts with an unfair prejudice petition, then the new unfair prejudice petitions proceedings rules will apply. We noted that in footnote, as we point out in footnote 2, there were precedents in which the petitioner has to apply for leave from the court. The judge then pointed out that for procedural considerations, the leave might not be approved. The court would request the petitioner to resubmit a petition in order to seek a winding up order. if a winding up request is also included, will apply the winding up rules as well. So the situation is clear. We're of the view that the existing rules are already sufficient. Members, any questions? Then we can continue. Legal advisor? Then we move on to Legal Notice 78. Is that correct? All right, we move on to Legal Notice 78 in relation to company records, inspection and provision of copies regulation. We'll proceed to clause-by-clause scrutiny. Mr. Yu, please. Thank you, Mr. Chairman. Concerning this company records, inspection and provision of copies regulation, we don't have that many clauses, altogether 13 of them. The first one is about the commencement date. As in other regulations, it's just like the Companies Ordinance. It's actually related to Cap 365. So this will take effect at the same time as the Companies Ordinance. Clause 2. Now this is an interpretation clause. This is to handle company records. Clause 2 explains what company records are. I'd like to say that under the Companies Ordinance, we have company records. Under the CO, companies have to keep records. Under Section 654 of the Ordinance, accountancy records are not included. In Part 9 of the new CO, there are separate provisions for the financial records. Here, company records mean registries, directors' registries, companies' registries, membership registries, or registers, general meeting records, EGM, special meeting records. Now, all those records covered by the CO will be covered under this regulation. Any question? No, then we can continue. Clause 3 is on the prescribed place for keeping company records.
And here we said it's a place in Hong Kong. There was a discussion on this when we examined the CO. And it said that sometimes some records might have to be kept apart from at the registry, company registry, because of the need of additional space or cost of rental and so on. So the company is allowed to keep their records in different places. Last time we said that office rental is high, that people may rent space in some warehouse for record keeping. So we said we would like to have some suitable amendments to accommodate this. Okay, we can move on to Regulation 4, Inspection of Company Books, Part 3. And 4 is on the interpretation of Part 3. Here we will talk about relevant provision, because the keeping of records and the inspection by the members and by the general public can be found in the ordinance. So here we are only talking about some relevant provisions in the ordinance which are related to this part. All right. Regulation 5. This is about the prescribed manner for making requests for inspection. According to the CO, a member has the right to ask for inspection of company records, and this request must be made to the company. And here we specify the manner of making such a request. It's a simple requirement. The person has to specify the type of records and also the dates on which the records were made, because without such information the company may not be able to take out the records for inspection. Okay, we can move on to Section 6. This is about inspection fee, and it stipulates that it's $50. By $50, we have to consider two things. In the CO, we specify who can ask for an inspection. For example, directors, registrar. A member can have access to the director's registrar free of charge. If it's free of charge under the ordinance, then the $50 here does not apply. But if a non-member wants to check at the membership register, then under the CO, a fee is payable. So here, $50 applies whenever a fee is required under the CO for some record inspection. This is just the maximum. The company is free to set a lower fee. Mr. Martin Liu, I want to talk about 11.1, and that is that the time limit to respond will be 5 working days instead of 7 calendar days. 5 business days is the new rule. I'm concerned that sometimes SMEs may not be able to make all the records ready within such a short time. Actually, we're talking about 11.1. Well, I can't follow you. You have jumped to 11. But maybe we can wait until we have reached 11. Regulation 6 is on inspection fee. All right, if there's no question, we move on to Regulation 7. And Mr. Yu, you may wish to respond to Mr. Liu when we reach Regulation 11. All right, we're now on 7, Regulation 7. This is about making company records available for inspection. And under the CO, the company must make records available for inspection by people entitled to inspect during business hours, subject to some restriction. But the restriction must be reasonable, and at least 2 hours per day must be allowed for inspection. So this particular regulation is in line with the CO. We did at one point consider whether an appointment would be required for inspection to be made. But we are mindful that this may have practical problems if we required a prior appointment to be made first. Here we would like to just make it a simple requirement that the records should be available during business hours. The company concerned and their members should work out suitable arrangements under this regulation. Another 2, bracket 2, according to the CO, for a certain period of time during the year, a register can be closed. And so subsection 2 says subsection 1 doesn't apply when the register is closed. What about 7(3)? Can you tell us about the penalty there? Well, if the company breaches subsection 1, that is making records available for inspection during business hours, and if this is not complied with by the company, and every responsible person of the company may be fined. We have changed the stipulation. There's no fine on a daily basis. We haven't found recent cases. And if this is going to be relied on for prosecution, then very often it will involve the member failing to have access to records when he approached the company for inspection. It's not like the late submission of certain records or information to the company's registry, and you may be late for 1 day or 2 days or a longer period. Here we talk about just a simple breach, and bracket 3 involves subsection 1, and according to subsection 1, the time allowed must be at least 2 hours per day. So beyond the 2 hours, the company can say that you should come the next day because it's not available for the day. Well, Section 7(1) stipulates that records must be made available for inspection during business hours, but sometimes the company may not do this in its entirety, so the company can pass a resolution, say it's only available in the afternoon. But it cannot stipulate that it's only available from 3 to 3:15, that is under 2 hours. But if for business reasons they are not able to make the records available for inspection in the morning, you may have a resolution passed to the effect that the records will be available in the afternoon of a business day. So there's an additional requirement that the time allowed on each business day must not be shorter than 2 hours. All right. Section 8. This is for the avoidance of doubt. If someone who is entitled to check company records, he is also entitled to make a copy of the records. That's an existing requirement. The person can make a copy, take a photo, and so on. But the company is not required to assist the person to make copies. There are other provisions asking for copies. So if the member wants to make a copy, invoking this right to make inspection, then he'll have to make the copy by himself. And subsection 3 says if subsection 1 is contravened, it's an offense. All right. Section 9, order of court relating to inspection of company records. If a person entitled to inspect any company records is denied access, he can make an application to the court of first instance, and the court of first instance can make an order to compel the company to permit an inspection, and also to specify the time, duration, and the manner of inspection. And the court may also Well, in response to an application on the denial of the right to make a copy, then the court may also make an order to compel the company to allow the person wishing to make a copy wishing to inspect the records to make a copy. And subsection 3, since we allow company records to be kept in different places, and so under section 3, if the denial of access has to do with a third party, for example, the person in charge of the storage place, then the court can issue an order to mandate that person make available the records for inspection. Okay. Part 4. Yes, Mr. Albert Ho. I want to return to section 6. $50. Is it $50 per request or $50 per page? Where section 6 is about inspection, so it's $50 per inspection. But this is only payable when the CO requires a fee to be paid. For example, a member can inspect the member's register free of charge. But if a member of the public wants to check the same register, a fee is payable under the CO. The fee is not specified in the CO, so $50 will apply. So you talk about the one inspection, but how much is covered by that inspection? For example, you can specify the date or period, say a period of 3 months. And I don't know how many pages will be involved. I want to check all the records, and do I have to pay just $50? Well, it's a per inspection basis, per visit, right? If you're allowed 2 hours, you can inspect whatever amount of records and copy whatever amount of records. Is $50, right? I think it's as practical and down to earth as that. Well, simply put, yes.
Within 2 hours, $50. How much you can do is your business. Well, the companies will definitely make a profit out of this. If the records are open for inspection, if I want 100 pages, 1,000 pages, I can go and have an inspection. I may finish that in 1 minute. It's $50. I may spend a day. It's still $50. Well, if I can't finish within today, I go tomorrow. What will happen?
Yeah.
So it would be another inspection period. So the inspection period, at least 2 hours, the $50 would be paid for that particular inspection in relation to that type of records and the date that it relates to. You see, we do have in the note, it's up to the company. They can decide. There is flexibility for them to charge nothing. If they want to charge for another inspection, arguably they would be entitled if it did fall into another inspection, if they had to make another request for additional records. Arguably, if it was a continuation of the same inspection, $150 fee.
Okay.
So it's really going to be a practical issue, I think, with flexibility for the company. But it's not such a significant amount, I suppose, that it's.
Any questions?
Mr. Alberto, any follow-up? Then we'll continue. We proceed to part 4. Provision of copy of company records by company. Mr. Chairman, the company provides copies to the relevant parties. Section 10 is related to the request for company records by a certain person, and that should come under the Principal Ordinance as well. We just try to tidy up the language used. If there's no question, we proceed to Section 11. Section 11 is about a request by a person who has paid a fee. Upon receiving the request and the fee, within 5 business days, the company has to provide the copy to the person. If the person requests a hard copy, the company should provide a hard copy. If the person requests for a soft copy, an electronic copy, the company has to provide the electronic copy. If the company has only got a hard copy, then it does not have to produce a soft copy. But if the company has a soft copy and the person requests for a soft copy, the company has to provide the soft copy. Just now, Mr. Liu mentioned the requirement of 5 business days. In fact, this is a change when compared with the existing laws. For copy to be provided by the company, it's subject to a number of requirements. In relation to this, it can range from 7 days to 20 days. And there is a certain degree of difficulty on the part of the company, which has to look at the nature of the records, as well as the duration during which the copy has to be provided. So here, we propose 5 business days. Previously, we did consider the possibility of 7 days. But then there were responses that sometimes within those 7 days, there may be public holidays, Lunar New Year holidays, etc., during which the company may not work. So we propose 5 business days, that is, public holidays, black rainstorm warnings, typhoon days, etc. are excluded. So it's precisely 5 working days, exactly working days for the company to handle the request. We consider that sufficient. Mr. Liu and then Mr. Kenneth Leung. For a normal company, 5 business days may be all right, but for an SME, due to manpower consideration, that may not be enough. So can you be more lenient on this? Mr. Yu, can you be more lenient? We have to strike a balance. If the person wants to obtain company records, he may not want to wait for too long. He may have to use the records for certain purposes. We have to consider the company's compliance costs, as well as the right of the person to request for copies within a reasonable time frame. So we have considered possible arrangements. Electronic records may suffice. So for a company, just an email will be able to handle the request. If the person has to wait for 10 days for a simple record, it may not be desirable. So we believe that 5 business days will be able to cover a week, actually. In the past, we said 7 days, so it's a week. So we now propose 5 business days. It's roughly a week as well. So the feedback was that this shouldn't pose too many problems. Rather, the responses that received would like to exclude public holidays. So we would like to strike a balance. Mr. Liao, in the past, is 27 to 20 calendar days. There's flexibility depending on whether the request is simple or complicated. But now you adopt a broad brush approach. It's 5 business days for both complicated and simple requests. This may pose difficulties to SMEs. I do not agree that, well, I'm not talking about a month. I suggest 7 to 10 working days. What difficulties will there be? The major difficulty here is that the flexibility is gone. For a simple request, 5 working days may suffice, but for complicated requests to SMEs, 5 business days may pose problems. Mr. Yu? Previously, I referred to the existing requirement of 7 to 20 days. It's not that the company can choose to respond in 7, 10, 11, 15, or 20 days. There were certain considerations previously that are no longer here. For certain records, it's 7 days in the past. For others, 10 days. So we just want to regularize the irregularities in the past. So in the past, there were discrepancies, and we'd like to improve on that discrepancy. As for the suggestion of 7 to 10 working days, it's a matter of striking a balance. The waiting time has to be reasonable, and we have to look at the company's difficulty in providing the records. We'll have to look at members' views. Mr. Kenneth Leung, I'd like to go back to Mr. Martin Liao's point. In the past, it's 7 to 21 calendar days, depending on the records requested. 5 business days is not a balance. It should be 10. Now, business days is the English version. It means a day that is not a general holiday. What about Saturdays and Sundays? Are they general holidays or not? Mr. Yu? Sundays are, but not Saturdays. Saturdays, no. So, if a company does not operate on Saturdays, that will only give the company 4 working days if the request comes in on Friday. So there'll be difficulties for certain companies, as Mr. Liao said. Now, if the company cannot produce the records within 5 business days, what will be the penalty? Is it Section 7, or do we have another penalty? It should be Section 11. Section 11.4 spells out a fine at level 4. What's that, level 4? What is level 4? How much? Level 4 fine, how much? $25,000. Oh, Mr. Chairman, you remember that? No? Our legal advisor provided that piece of information to me. $25,000 is a heavy penalty. Overall speaking, we should give them more time. 10 working days will be better for the whole regulation. 5 business days. As I said, if Saturdays are not general holidays, the time frame is too tight. Mr. Cho, legal advisor. Thank you, Mr. Chairman. I'd like to provide members with another piece of information for consideration. Under the existing Companies Ordinance, Cap 32, apart from a level 1 fine, there will also be a daily fine. That is, apart from an overall fine, if the offense is repeated, that is, if the copy of the records is not provided, then in calculation, a daily fine can be imposed. The regulation does not have this provision. This is for members' information. I'd like to ask a similar question. For each company, in particular an SME, is there any ceiling to cap the number of requests to be handled by the company at any one time? 5 business days may not be enough to handle many requests because there may be different degrees of complication. Mr. Yu, there's no such ceilings. For actual operations, some private companies may only have 3 to 4 staff members. And the number of members may also be very few, 3 to 4 maybe. For a listed company, it may have more members and there are more resources. But that's not the case for non-listed companies. When we discussed with the industry, we did not note any reminder that many requests may have to be handled at any one time. But if any member has any suggestion in that regard, we are pleased to consider it. Members, do you have any suggestion? Mr. Kenneth Leung suggested 10 days. Does this committee have any consensus on this? Any objection? Mr. Ronnie Tong? Mr. Kenneth Chan? Any comments? 10 days is suggested. Bureau, would you please consider that? All right. So the Bills Committee won't move an amendment. The Bureau will go back and consider this suggestion. So, Mr. Liao, are you all right with this 10 days? If you move an amendment, we'll support it. You mean 10 working days? Yes, just change 5 to 10. It's just that simple. All right, then we move on to Section 12. Thank you, Mr. Chairman. Section 12 is related to prescribed fees for the provision of copy of company records. At present, there are 2 categories of fees. Basically, there are 2 categories of records. First, registers with various items, say the names of members. So the number of items will be the basis.
So for the first 2,000 entries, $5 for each 10 entries. For the remainder of the entries, then $1 for each 100 entries. For private companies, well, the number of members is under 50, so we don't have thousands of entries. But sometimes a request may be made about the membership register of a listed company with thousands of entries. So anything over 2,000, the fee is reduced. So we want to prevent a situation whereby a very high fee has to be paid if you want to inspect a register of a listed company. If it's not in the form of entries, then we will look at the number of pages, $5 each page. Mr. Kenneth Leung, are you talking about A2, A3, A4 page? Do you have any standards? It can be a very big page if you have the right machine to print it out. Well, if it's compared with the existing CO, we are now proposing a change. The existing CO is word-based, the number of words. You may think the number of words may be more accurate. But then you have to have someone counting the number of words before you can calculate the fee. So that's not really practical. So we talk about $5 a page, but we do not specify the size of the page, A5, A4, or whatever. It's difficult, right? Sorry, let me ask you to go back to Section 8. Making copy. Apart from making copy, you can also take some notes, or you can use a photocopying machine, or you can take a photo with your mobile phone. And you can also keep something electronically. And if I have a USB thumb drive and I want to make a copy, is that allowed? Does making a copy include making a copy electronically, say by using a USB thumb drive? If you are talking about Section 8, then everything is covered. It doesn't really restrict the means of making a copy. If the company has something kept electronically, and if there's a computer system that allows you to make a copy, then you can do it under Section 8. But the company has no duty to help you, to assist the person in making a copy. Well, but the company owns the computer in question. When I insert the thumb drive, USB thumb drive, well, I'm violating the property rights of the company. Is the company entitled not to allow me to use my USB thumb drive that way? But according to this section, the company cannot refuse me if I want to make a copy. But on the other hand, the company can refuse access to the computer. So is there not a contradiction? When we talk about making a copy, the first thing that comes to mind is to making a hard copy. But you now also have soft copies. But so how do you count the number of pages? For example, if it's an electronic record, I think our regulations have to keep up with the development of technology. Chairman, maybe let's talk about the principle first. Section 8 stipulates that the person has the right to be permitted to make a copy, but if the company has security considerations, or the company doesn't want people to access other information. So first of all, the company doesn't have to make the records available in the form of electronic records or in the form of computer files. The company can just make hard copies available. And when a copy is to be made, then if the company has a security consideration, the company can offer assistance in making a soft copy available, but the company has no obligation to assist the person in question. But the company is equally not barred from offering assistance. If it wants to assist, it can. So if you want to take a photo or a copy of the records, you can, but the company can prevent you from taking a photo of other things other than the records. We believe the company is is allowed to help you make a soft copy if it wants to. As for the other thing about the number of pages, well, here we do not cover soft copies. If I want to have company records related to a certain period and I want to have some copy, then the company will have to send someone to take out the record and to make a copy available, whether it's a hard copy or a soft copy, before making the records available to the person requesting this. So some cost is actually involved, but the biggest cost is not actually the photocopying cost or the cost of paper, but rather the manpower. So here we just specify the number of or the fee per page, and we do not make a separate provision for soft copies or computer copies. But for entries, you count the number of entries, and if it's an electronic database, you do the same, right? Yes? All right. Questions? If not, we can move on to section 13. Well, this mirrors a previous section. If a person asks for a copy of some company records, and if the person is not provided with a copy, he can apply to the court, and the court can compel the company to provide the person with a copy of those records. And under subsection 2, if the failure is on the part of a third party, then under subsection 2, the court may also make an order to compel that third party to make available a copy. Yes? Legal advisor? One of the empowering provision is section 657, and under 6575C, if someone requests some information from a register or from some index, then the company is entitled to tell people the last revision date. And that is to say, under the CO, subsidiary legislation can be enacted to provide for this. But now we don't have this in this regulation. So maybe the administration can explain why we don't need to have anything in the form of subsidiary legislation on providing the information that I've just referred to in the CO. Well, if we were to do this, we would have to do something different. Under the CO, there is no requirement on indicating the last revision date. So this is not being done. And second, we haven't heard from the people or people who have strong views that we should do this, because this involves some costs on the part of the company. They will have to keep proper records on the number of on the dates of revisions, and every time an inspection or a copy is asked for, the company will have to inform the person concerned. So for the time being, we don't see a need to enact subsidiary legislation to indicate this. But we don't have this. In other words, we don't have this for the time being. If the person needs to check this piece of information, can this be one of the requests under an inspection? It has to do with Section 12, because it's a fee per entry. Can this be regarded as one entry? I want to check the latest revision date or particulars regarding the last revision. Can I put this down as a request? Is that a request for an entry? Well, the entry we're talking about is those entries in the membership register. If there are 5 members, you have 5 entries. If you want to have a piece of information, a particular request, it's not one additional entry. It's an additional request for information. Under the law, the existing law, the company doesn't have to provide that piece of information. But if the company can do it, there's no prohibition as well. If the one making the request wants to find out this piece of information, maybe it's related to changes of members over time, changes of directors over time. I wanted to know the delineation of responsibilities during different periods of time. So can the information be identified in the current version, current registers? And is the company not obliged to provide past information? Under the law, the company is not obliged to provide information on the last revision or change. Under the new CO, whenever there's a change of director or directors, the company must inform the company's registry. So a much more straightforward approach will be to find this piece of information from the company's registry concerning appointment and resignations of directors. So you mean another approach is much more straightforward, okay?
If there's no further question, then we complete the scrutiny of LN 78. Let's proceed to LN 79, Companies Non-Hong Kong Companies Regulation. Thank you, Mr. Chairman. Companies Non-Hong Kong Companies Regulation is to handle companies not set up in Hong Kong. For companies set up overseas, if they have business offices in Hong Kong, they have to register with the company's registry. Under the CO, accounts, changes of company name, etc., are covered by Part 16 of the CO. There are reporting requirements. Detailed arrangements and requirements have already been provided in the new CO. The regulation deals with details and technical matters. Take, for example, registration, what has to be filled in the registration form, etc., etc. All these are covered by this regulation. And very often we have to compare this regulation with the CO. Some requirements appear in the CO and details are set out in this regulation. So that's the principle underlying the regulation. Let's proceed to clause-by-clause scrutiny. Section 1, commencement. This regulation comes into operation on the day of the new CO. No question. We proceed to Section 2. Section 2, interpretation. Interpretation for expressions applicable to this regulation. Usually, we use the interpretations in the new CO. Mr. Chairman, technically, Well, Mr. Cho, legal advisor, for Section 2, Mr. Chairman, interpretation, in the Chinese version, there is this definition for 成立所在地. It should be place of incorporation, but that's not found in the English version. I would like the administration to explain to members why this is the case. Mr. Yu? Mr. Chairman, perhaps I should defer to the Law Drafting Division. Yes, who will explain this? Omitted? No, perhaps I should explain. 成立所在地 in the CO means the place of incorporation. In this regulation for non-Hong Kong companies, a number of provisions have used the term place of incorporation to make the regulation more concise and precise. In the Chinese version, we've added 成立所在地 as one of the interpretations. Place of incorporation, when mentioned in the regulation, can use this definition. In sections 3, 4, and 9, we have such provisions. Why is it that in the English version we do not have a corresponding interpretation? Because under the Interpretation General Clauses Ordinance, Section 10b, we should look at each version independently. It's not necessary to have a corresponding expression in the English version whenever there's such an expression in the Chinese version. In the CO, court with a capital C is in the English version, but there's no corresponding term in the interpretation clause in the Chinese version. Court of first instance needs to be mentioned. So that's for members' consideration. Mr. Yu, any supplement? We don't have strong views here. Well, Mr. Cho, we don't have strong views here. In the Chinese version, it is feasible to translate that into English. The administration is of the view that place of incorporation is already very clear and it does not need an explanation as in the Chinese version. They consider no ambiguity here. Mr. Kenneth Leung, what about Part 2318 in English version? We've not yet come to that yet. Well, you said Part 1 is not problematic. Well, let's resolve this 所在地 first. So just wait, be patient. Other members, what do you think? Well, our legal advisor have raised this concern. Do we accept the Law Drafting Division's explanation? All right, then Mr. Yu, you can proceed with the next part, and the Deputy Chairman will have questions. Section 3 is related to particulars to be contained in application for registration. The ordinance does provide that non-Hong Kong companies, if they set up offices in Hong Kong, have to be registered. Section 3 spells out the information to be provided to the company's registry. The details are set out in Section 3. Particulars of the company, company's name, place of incorporation of the company, the date on which the company established its place of business in Hong Kong, director's date of appointment, addresses, ID particulars, information related to the secretary of the company, as for the company secretary, the particulars to be provided will be the same as those under the CO, and a correspondence address have to be provided as well. Same for Hong Kong companies and non-Hong Kong companies. Deputy Chairman, What about 3(1)(a) in relation to the company's domestic name? In the English version, it is company's domestic name in Roman script or Chinese. What do you mean? For the Roman alphabet, you need a script form, and then you need a Chinese form. Would you require that the name used in Hong Kong should be the same as that used by the head office? Mr. Yu, as for the requirement in 3(1)(a), we're talking about the domestic name, that is the name in the place of incorporation. It can be in Roman script or in Chinese, but it has to be the domestic name. If a company has used an English name as well as a Russian name, then they don't have to provide the Russian name, because the company's registry may not be able to register the Russian name. So the English or Chinese domestic name has to be provided. Deputy Chairman, by Chinese, do you mean both the traditional Chinese characters and the simplified Chinese characters? Yes, Mr. Chairman. If there's no question on Section 3, we proceed to Section 4. Thank you, Mr. Chairman. Section 3 handles particulars provided. Section 4 is related to documents to accompany application for registration, including the charter, statutes, or memorandum of the company. If such documents are not in English or Chinese, then the company has to provide a certified translation in English or Chinese. This requirement will appear in ensuing provisions. That is, if the original document is not in English or Chinese, we'll ask for a certified translation. B, a certified copy of the company's certificate of incorporation. And then in terms of accounts, for an overseas company, the law of the place of incorporation and the place of listing, and which may require accounts to be prepared in the place of listing, then the accounts have to be submitted to the company registry as well. If the overseas jurisdiction does not require accounts to be prepared, then the company has to state that to the company's registry. Because for an overseas company, we have to look at the requirements of the overseas jurisdiction. So if the laws of the overseas jurisdiction concerned does not require the accounts, then the company's registry won't require the accounts as well. By accounts, what do you mean? The accounts of the head office or the accounts of the branch office in Hong Kong? That is, if the Hong Kong branch keeps a copy of the accounts. So what accounts do you mean? Mr. Yu? Mr. Chairman, we're talking about the accounts of the whole company. That is, we use the company as the basic unit. I'd like to seek further clarification. For the Hong Kong branch, is it statutorily required to provide to you the accounts of the Hong Kong branch annually? No. If an overseas company set up a place of business in Hong Kong, which may just be a shop, then we don't require separate accounts for the shop. If there is a Hong Kong branch, then the Hong Kong branch will have to prepare accounts in accordance with the laws of Hong Kong. But if it is just a place of business in Hong Kong of an overseas company, then we don't require separate accounts. By certified copy, what do you mean? Who is to certify?
Copy in section 775 of the primary legislation. So if I can take you to the primary legislation, there is quite a long section detailing who can and who cannot certify and what will be accepted for the purposes of this particular regulation. So it's already in the primary legislation, section 775 of the new CO.
Can you bring me to that?
Certainly.
Yeah.
主席，或者我將有關條文。
Mr. Chairman, perhaps I should roughly explain that provision to you. Government officials, notaries, lawyers, professional accountants, court personnel, professional company secretaries, etc. Hong Kong notaries, Hong Kong lawyers, Hong Kong accountants, court personnel of Hong Kong, and personnel of the consulate and the company secretary if there's a Hong Kong branch. That is volume 4 of the CO. A4784, that is the page number, and A4785 for the English version. Mr. Ho, any follow-up? It's simpler than the Hague Convention, which is quite complicated. It seems that a whole list of people can do certification. So the requirement is being relaxed, isn't it? No problem. Mr. Chairman, sorry. One more question. Certified copy for either the English version or the Chinese version, right? Correct. Legal advisor for 44A. I'd like to raise a concern about consistency between the English and Chinese versions. In English, 44A, date of delivery of the application under section 7764 of the Ordinance. In the Chinese version, the duration is set out as 18 months. In the English version, it is the date of delivery. Maybe the company completes the task in 10 days' time. That is before the expiry date. So how do you count? According to the English version, it should be the date of delivery, counting from the date of delivery. But for the Chinese version, it is 18 months before the required date of delivery. In the Chinese version is required date of delivery. Mr. Chairman, perhaps I should briefly explain this. We understand the comment of your legal advisor. In 7764, if you look at the section itself, the application has to be submitted. Here it says the application under section 7764 of the Ordinance. It depends of what application it is. So it is the actual duration of 18 months. The meaning and the actual operation are clear. But of course, 91K has something similar in relation to the translation issue raised by your legal advisor. We'll go back to see whether there's any room for improvement. All right, the legal advisor has already raised this. Next time, please give us an exact reply.
Anything else, legal advisor? No. Now we are on part 3, certified translation of domestic name. And that is section 5. Thank you, Chairman. Section 5. Company may include certified translation of a domestic name application for registration. But there are provisions already in the Principal Ordinance. If a company has a domestic name not in Roman script, then we can have a certified translation in Chinese or a Chinese name as a certified translation. So it's at most one Chinese name and one English name. All right, section 6. If there's a change of domestic name, then applying the same principle, if the domestic name is not in Roman script or English or in Chinese, then the company can register a name in English and also in Chinese. Section 7. Thank you, Chairman. Section 7 is about application under Section 5 and return under Section 6 and the information required to support an application. So what is required would include the domestic name and the certificate of incorporation and or the date and the date of the certificate. And if the documents are not in English or Chinese, then a certified translation must be submitted to the company's registry. All right. Part 4. Notice of termination of authorized representative. Section 8. According to the ordinance for non-Hong Kong company, an authorized representative is required if the company has terminated an authorized representative, then the company's registry must be notified. And the company must provide a copy of the written notice of termination. And if it's not in Chinese or English, then it has to provide a certified translation of the written notice. All right, Part 5, particulars required for annual return, and that is Section 9. Thank you, Chairman. Section 9 is about the particulars required to be furnished in the annual return by a non-Hong Kong company. For example, the place of incorporation, the corporate name, the date of registration of the company, the principal place of business, etc. And like local companies, there's the information on directors, authorized representative, and secretariat, company secretaries, and so on and so forth will be required. Legal advisor? In 9(1) H1, Roman 1, again, there's a discrepancy between the Chinese and the English version. Name is the word used in English, but in Chinese, you don't know whether this is about the name of a company or a natural person. So there are two terms in Chinese, 姓名 or 名稱 for the term name in English. So if it's natural, person is a 姓名, but it can be the name of a company. Therefore, we may need two terms, 姓名 and 名稱, to render the English term name. Well, I will revert to the subcommittee in one go concerning translation of terms. Okay, if you agree, then you move the amendment and we don't have to do it, right? Correct. Part 6. Revision of accounts under Section 790 of the Ordinance. Section 10. Under some circumstances, non-Hong Kong companies have to submit the accounts to the companies registry, and here, if the accounts have been revised, then some other things must be done. We provide in Section 10 what the definition of different terms, original accounts and revised accounts, for example. Okay, Section 11. Section 11. The company is required under this section to deliver revised accounts to the registrar, and this is the same as local companies. If accounts have to be revised to meet certain legal requirements, and the company has to deliver the revised accounts to the registrar, and other information is also required. For example, there should be a statement specifying that the revised accounts replace the original accounts for the financial year specified in the statement, and also a statement specifying the respect in which the original accounts did not comply with the regulatory requirement. And if the revised accounts are not in Chinese or English, then a certified translation is required. And then there's also a penalty for non-compliance. All right. Questions? If not, Section 12. Section 12. Effect of revision after delivery of a revised account to registrar. And Part 16 of the ordinance would apply to the revised accounts after the revised accounts have been submitted to registrar. Okay. Part 7. Change of register particulars. Section 13. Section 13. In relation to a non-Hong Kong company, if there's a need to change some particulars, then certain particulars have to be contained in the return to be submitted to the registrar. For example, the matters in concern, the new particulars after the change, and the date on which the change is made. All right. Section 14. If the changes are related to the memorandum, articles, or other constitution instruments, if the charter is amended, that the amended charter must be submitted to the registrar for registration. And again, if the charter, statute, etc. is not in Chinese or English, then a certified translation is required. Legal advisor, again, a drafting point is in relation to Section 14(2), bracket A. And that is the company has to inform the registrar, and then the revised documents must be attached. And in 14(2)A, It says after the change. We're talking about different things, charter, statutes, or memorandum, articles, and other instruments as a catch-all. And that is to say, you have to attach all the revised instruments and documents. But this is not clearly reflected in the Chinese version. Maybe some revision is required. Well, the legal advisor is correct in relation to the policy intent. We'll look at the Chinese drafting one again. Yes, please try to make it clearer in the Chinese version. Questions, members? No? It seems that we are very efficient today. LN 80. Is the next one, but Winnie is on leave. So we have to deal with LN 80 next time. Regarding meeting dates, the next one will be held on the 20th of June. It's a Thursday. We'll start from 2:30. There are two sessions. It would take us to 6:30 p.m. We also earmarked another two slots, 24th of June, from Monday 10:45 to 12:45, and again, 25th of June, 2:30 p.m. to 6:30 p.m. We have earmarked we have earmarked many slots, just in case we need them. I believe we are not going to use them all. So Thursday, 20th of June, we're going to have two sessions. I believe we can deal with LN 80. We are also going to deal with companies model articles notice. And companies fees regulations. So the next meeting will last for two sessions. I hope that will be sufficient. We may have to extend the scrutiny period to the last day of our current legislative session, that is to say the 17th of July. The deadline for submitting a report to the House Committee is the 5th of July, and the notice required for moving amendments is 5 days before that, and that is 5 days before the council meeting, and that is to say the 10th of July. If you want to move amendments, you have to do it by the 10th of July.
The administration has already heard members' views and our legal advisors' views in the course of scrutiny. Next time the Bureau should inform us whether the Bureau would move corresponding amendments or this Council will move corresponding amendments. I'd also like to inform members that concerning the unfair prejudice petitions proceedings rules, at the last meeting, members agreed that the administration should move a resolution at the council meeting on the 17th of July. If there's no other business, this meeting can be adjourned. So our next meeting will be held on the 20th of June, Thursday at 2:30.